Yes.
May it please your lordship. Now, my lords have seen
What
that
are documents you have produced before the court in support of
look,
your case?
I have produced the certified copy of the surrender deed, registered surrender deed, and both the courts below, my lords have seen that it has held it to be a genuine document. Page 13, my lord will find uh, a separate issue, page 13, second line, a separate issue on the point of surrender being issue number 6 was framed by the trial court, and the learned court below has held that surrender to the land through registered sale deed was a valid surrender. And therefore, and the same has been upheld by the learned lower appellate court. So in this view of the matter, the respondent, my lord, the descendants of the person who surrendered the land, my lord, they don't have any nexus and to the title and interest in the property, my lord.
The issue is you are the plaintiff.
I am the plaintiff, my lord. Yes, yes,
You want to prove your case.
yes, my lord.
You have to
My
show that you have acquired valid title
yes,
from
yes.
your purchaser, and your
My
purchaser had a valid title. Show me the chain. Show me the link.
yes. Now, my lord,
Is this what
same
is registered deed? Registered sale deed dated 28/11/1955. What is this?
well, this was a sale deed executed by Sheikh Nizamuddin in favor of one Muslim from whom I have purchased 30 decimal, and I had purchased,
How did this Nizamuddin got the land?
he was given by a oral sale by the landlord, Jamindar, in September 1947, my lord. So there is point for consideration by this honorable court.
Purchased when? You
I
purchased
purchased in 1960, my lord, 50 decimal from Sheikh Nizamuddin, and in 1960, 30 decimal from Muslim. And we have
1960.
no 60, 30 decimal, and 50 decimal from Sheikh Nizamuddin directly earlier, my lord. And my lord, no oral evidence has been discussed either in the trial court or in the appellate court judgment, my lord. Although there are several oral evidences on behalf of both the parties. Not a single witness has been discussed, my lord.
Now tell me one thing.
My lord,
Now tell me one thing.
my lord.
You are in possession over the land in question.
I am in possession.
Now who is challenging your? Now who is threatening you?
My lord, the descendants of the person who had surrendered the property.
So in
Descendants
the court, those issue has been answered against them.
against them, my lord.
So now what is the problem? You have you
In
have
fact,
listen to me.
my lord.
You have failed to prove your title by purchase. Yes, because the court held that the person who allegedly purchased the land
Sheikh
from the,
Nizamuddin.
yes, Sheikh Nizamuddin,
Settlement. Yes,
no
yes.
document that it was sold to
Yes,
Sheikh Nizamuddin. Now Sheikh
my lord.
Nizamuddin in possession, it was not there.
My lord, my lord.
So if that person has got no title, he cannot transfer any better title to you.
Yes, yes. That is a proof.
Now the second question, you can claim title is by a way of adverse possession.
Yes, my lord.
Now adverse possession against whom? Against the real owner? Against
Against the person who said who
no, no,
surrendered.
against no. Adverse
Or
possession is
against
against
the
the real owner.
entire world, my lord.
Court,
Yes.
the court held that those defendants were
My
not
lord.
the real owner.
Not the real one.
So, so this if someone is disturbing you now,
My
you
lord.
can file a suit for adverse possession against that owner. Because when the court has held that the defendants are not the real owner after the
My,
transfer,
yes.
so I don't think so that anything remains so far as you are concerned. And and so far as the finding that you have failed to prove the title
Yes, yes.
by adverse possession by way of sale deed, but
By
it's
way of
there,
settlement to Sheikh
there is
Nizamuddin.
after surrender there is nothing on record that it was sold to that person.
A settled to Sheikh Nizamuddin.
Yes, there
By
is nothing.
there is
From
yes,
Nizamuddin, see, there is from Nizamuddin, there is a sale deed in your favor.
yes, yes, yes.
But
From 1960, I am in Pakistan.
when you are claiming title
Yes,
by virtue of a sale deed, it has
yes,
to be seen if it is challenged. It has to be seen whether Nizamuddin had got a title or not.
yes, yes, yes,
So,
yes,
what else that there is nothing on record to suggest that that Nizamuddin purchased the sale land.
yes.
So,
This
so, so, so the court disbelieved your case
yes,
that you are the owner or you are the title holder by virtue of a sale deed. Now is the question of adverse possession.
adverse
And
position.
has been decided in issue number 3 that defendant number 1 cannot claim the property. They are not the owner. Come to page 17 of the trial court judgments.
Yes, yes, my lord. Yes, my
So,
lord.
so now in future, if someone disturbs you,
My lord.
claims himself to be the owner,
Yes,
you can now in view of the latest judgment of the Supreme Court that a suit can be filed claiming title by adverse possession. Earlier it was a shield, now it is a sword also.
yes, yes, yes.
So then what remains?
Issue number 3, I am obliged.
Read issue number 3.
So far adverse possession is concerned, it is settled principle of law that adverse possession is always against the paramount owner and the case in hand. The plaintiff has claimed himself in adverse possession against the defendant. But as discussed above in issue number 6 is below.
Read that. I have read issue number 6.
It is held that predecessor in interest of the defendant surrendered the suit land, and therefore, after surrender of the suit land, the defendant of one was not owner of the suit property. So the defendant also did not require any acquire होना चाहिए require any right at any interest over the suit property, and no adverse possession.
The court has held that the defendant number 1 is not the owner of the suit property.
My lord, my
Then,
lord. Then I'm in possession.
then finished.
So on this, my lord, if my lord passes a order, then that will benefit the person who is in possession since 1960. I will be benefited, my lord. On the finding of the court itself, issue number 3.
Where is the question? Where is the issue of your possession decided?
Just a minute. Issue number 3 was in the trial court, my lord, and
Trial court issue number.
3, my lord. That at page 50, para 50, my lords have asked me to read. So far, appellate court is concerned, page 11, my lord will find there is no issue like with regard to adverse possession, my lord.
Where are the issues?
Issues at page 11, my lord, of the judgment, running page 19. Points for determination. It is
Page.
page 11 of the judgment, appellate court judgment. Para 10, my lord, find points for determination in appeal. Initially, the court writes a paragraph and then frames the questions to be decided, points for determination. Here, there is nothing like adverse possession.
Take down. This appeal will be heard on the following question of law: whether both the courts below, by not framing an issue in respect of the possession of the petitioner over the land in question, has committed grave illegality, as the plaintiff plaintiff has claimed possession over the suit land since 1960, whether it was incumbent upon the court, both the courts, to give a finding, to frame an issue in respect of possession and to give a finding on the same, since the appellant, the alternative prayer of the plaintiff, uh, was that was in relation to the possession of the property, which according to the plaintiff is from 1960.
60 and 76, my lord. Other sale was from 76.
1960 and 1976.
My lord, my lord.
Full stop. Whether even if the finding of the both the courts are accepted, finding in respect of title, finding in respect of title, uh, which is against the plaintiff, is accepted, then also the court below should have decided the issue of possession, should have decided the issue of possession. Full stop. Issue notice. Call for the lower court record.
Obliged, my lord.
And Mr. Sahai, I don't think so that you are any aggrieved. In practically, you will be aggrieved by these judgments.
Only cloud is there over my.
That is a compelling finding of fact that there is no document.
G. Yes, yes.
Yes,
I must say, my lord, that I'm from core of my heart that I'm very much obliged and thankful to the view taken by this honorable court.
Ticket number 28.
Obligement.
Number 60. Mr. Rajan Sahai. Nanda Kumari.
Because the office is directed to translate both the judgments of the trial court in English. Trial court and the appellate court in English. Just a minute. What is the appellate court judgment? Yes. The office is directed. The office is directed to get the both the judgments, complete judgments.
Ticket 29. Second appeal 74 of 16. Mr. Neeraj Kishore, Ms. Vandana Kumar Sinha, Ms. Vipul Vidya for the appellant. Mr. Aishwarya Prakash, Mr. Sri Prakash Jha for the respondent.
Yes. Yes, who is appearing? Who is appearing for the appellant? Pass over.
CL 30, second appeal 81 of 16. Mr. Arun Kumar for the appellant, Mr. Ajit Kumar Singh, Mr. Pratik Sen, Mr. Gaurav Kumar for the respondent.
Please, Your Lordship. The second appeal, my lord, against the judgment of reversal, and the appellant is the plaintiff, my lord, was the suit, my lord, brought by this plaintiff for declaration of the gift deed, executed by Mosema Tumki to Lohrain in favor of her damad. The Sudhu Lohra is the defendant, my lord, the null and void, my lord. Only questions, my lord, before your lordships, whether this petition, whether the plaintiff, whether the defendants, both the parties, they belongs to from the member of backward class or from the member of the scheduled caste, scheduled tribes, my lord. Secondly, my lord, they without challenging the previous decree can be set aside, my lord, in subsequent suit, my lord. This is the two questions before your lordship, my lord. But
Previous degree
the
means?
previous decrees, my lord, the earlier also, my lord, they filed a suit, my lord, for for declaring null and void the gift deed, my lord, they executed by the Thumki Urai, my lord, the mother-in-law of the defendant, which was decreed in favor of plaintiff, my lord. But in that suit was filed, my lord, in form of the partition suit, my lord, and that was the decreed in favor of the plaintiff, my lord. Thereafter, my lord, again he executed a registered gift deed, my lord, in his the brother, in his son-in-law, my lord, saying he is the Gardamad of Tumki Urai, my lord. And my lord, but that decree which was the suit was the decreed in favor of the plaintiff in earlier suit, my lord, that was never challenged, my lord, by the defendant, my lord. But in
Just tell me whether in any suit this execution of this gift deed was under challenge.
yes, my lord, yes, yes, my lord. And
And
earlier,
what was held?
yes, my lord, in it has come, my lord, in trial court judgment, my lord, in page 35, my lord, page 35
Page 35.
of the trial court judgment, my lord. Running page, my lord, 35, my lord, running page 35. While deciding the issue number 6, my lord,
Read that. Read that.
while the accordingly the perusing the evidences the available in the case record, the considering the argument of both the parties and also considering the above the said discussions, it appears to me that the judgment and decree passed and prepared by the learned Munsif Gumla have not been challenged, and it is evident from the Exhibit 2 and Exhibit G. The learned Munsaf has held that title suit number 2286 that the parties of title suit number such and such are the member of scheduled tribe. It has the further held by the learned Munsaf that the plaintiff, the wing, the nearest agnates is the entitled to inherit and succeed the property left by Firan Lohra, and the defendants they have got no right to execute the partition deed in uh, in parties deed in questions, the defendant number one is the only entitled to maintenance from the land of her husband, and she is the not entitled to alienate the property, and the married daughters are not entitled to get any share in the suit land. It is the also admitted fact that the plaintiff of this case was the plaintiff in title suit number such and such, and the defendant number one, the Mosema Tumki Lorraine, since deceased of this case, and her two daughters, they were the defendant in the title suit number such and such. It is the also admitted fact that the lands of partitions deed as they mentioned in title suit number 2286 they are the same with the lands of gift deed as challenged in this suit. It is the also admitted fact the gift deed number such and such dated 8/3/6/91 was the executed by Srimati Mosemat the Thumki in favor of defendant the Sudhu on 3/8/1991, and Honorable Supreme Court that has they delivered the verdict about the Lohar and Lohra in the year 1996, that they means that the Thumki executed the said gift deed the here exhibit B much before the verdict of the Honorable Apex Court. It is the also admitted fact that even after the verdict of Honorable Apex Court, the defendant of this case, they have not challenged the judgments and decree the past, and they prepared in title suit number such and such. It is well settled that the decisions pronounced by the court of competent jurisdictions is the binding between the parties, unless it is the modified or the reverse the adopting a procedure prescribed by law. It is also settled principles that the earlier judgments they may seem to be not the correct. It will have the binding effect on the later bench of the of coordinate jurisdiction of the coordinate jurisdictions. It is also the settled principles of law that the order the passed by the previous proceedings rightly or wrongly they made the unless set by any higher authority they would be operative and binding on the parties. The considering the above said discussions and also the considering the judgments of the Honorable Apex Court and Honorable High Court, the, and as it is not a case for declaration of caste of parties, I find and hold that the judgment and decree passed and the prepared in title suit number is the binding to the Mosema Thumki Lohrain, as it has never been challenged before the competent court. Hence, the answer of this issue is goes in favor of the plaintiff and against the defendants. But, but without challenging that finding of this, the earlier findings of the earlier decree, my lord, by the defendant was the learned appellate court, my lord, they set aside the decree of the earlier suit, my lord, of 2286, my lord. And on that suit, my lord, and in earlier suit, my lord, it has been held, my lord, this
You are
the
the plaintiff. You are the plaintiff.
I am plaintiff, my lord. In both the cases, I was plaintiff, my lord.
No, in this
Yes,
case,
my lord. In
it
this case,
was your
plaintiff, my
case
lord.
for a declaration that the gift deed executed by Mosammat Chunki Loharin in favor of Sudhu Lohara as valid,
Yes,
as void, as void.
yes, my lord. Yes, my
So,
lord.
so by this issue, this issue was decided in your favor. So
Earlier, yes, my lord. Yes, my lord. In trial court, my lord, in my
the
favor, my lord.
trial court decreed that uh, the gift deed is void.
Huh.
Then
Yes, my lord. Trial court decreed, my lord, the gift deed executed by the Thumki in favor of Sudhu is null and void. But, my lord, appellate court says, my lord, as because the defendants and both the families are the belongs from the member of backward class, therefore
where is
they
the
govern from the Hindu Succession Act.
where is
So
the
he has
What is the appellate court judgment?
Yes, my lord. Appellate court judgment, my lord. The finding, my lord, of the appellate court judgments, my lord, from page
Internal page 10, my lords. Internal page 10.
page 12, my lord. Finding, my lord. Thus, on the basis of above case law,
Just,
that
just a minute, just a minute, just a minute.
yes, my lord, yes. It starts from page 10, my lord.
Just a minute.
Last two.
CPC दीजिए. Yes, Mr. Sen.
Yes, my lords.
Where is the issue that whether the parties are member of the backward class or scheduled tribe?
No
Where,
point of.
where is the issue framed whether the parties are governed by the Hindu law or their customary law? In absence of issues, you cannot expect a party to lead evidence on these points.
Order 20 Rule 5 covers that thing, my lords. That I do not dispute that, my lords. That judgment, the issues have to be there. My contention was, my lords, that
This appeal will be heard on the following question of law. Whether the judgments, order 41, yes. Because whether the judgment, whether the judgment of the appellate court is not in consonance with order 41, rule 31 of the CPC. Full stop. Next to whether in absence of any issues framed both the uh, by the trial court and the appellate court to the effect as to whether the parties are member of scheduled tribe or not, and whether they are governed by their own customary law or by Hindu law, comma, the appellate court could have come to a conclusion that the parties are governed by the Hindu laws.
Uh,
Yes,
It was due, the basic claim of the appellant was with respect to gift deed, my lord. So whether I had the competence to execute the gift deed in favor of me or not, that was in challenge.
if you are governed by Hindu law, the parties have the power. If you are not governed
Yes,
by Hindu law, then not. This is the
yes,
issue.
absolutely. This is the issue. This
Not even framed. This
yes,
issue
my
was
lord.
not even framed. So,
4113 is not.
any further, the court may frame any further point of law at the time of hearing. Full stop. Since the respondent has already appeared and
LCR is also here, my lord.
accepts notice, it is not necessary to issue notice to them. LCR is here.
Yes, my lord. LCR was called for the last occasion, my lord, on 17/12/2018, my lord.
1712.
Yes, my lord.
Yes.
And I have deposited the special messenger, my lord, for that, my lord. First of a special messenger for that, my lord.
You have not deposited the cost.
No, my lord, I have deposited, my lord. Later on, I have deposited.
Later on.
Yes, my lord. Challan is there, my lord. I have deposited, my lord.
When have you deposited?
उसका चलन कहाँ है जो जमा किया था इसने एक
Yes, yes, yes.
23/8/18 को
Yes, yes.
Serial 31, second appeal 92 of 16. Mr. Abhishek Kumar, Mr. Abhishek Kumar Singh, Mr. Siddharth Kumar.
In this case, Lordship, give me a pass over, Lordship, for one or two cases, Lordship. Much over, Lordship.
Serial number 32, second appeal 129 of 16. Mr. Ashwin Kumar Sani, Mr. Vikesh
May
Kumar.
Lordship. May Lordship. This appeal, Lord, it appears on the board, Lord, there is an interlocutory application for condonation of delay of 164 days, but it has been listed along with that IM, Lord. But the limitation has not yet been heard by this honorable court, Lord.
Let
It
me
was
see, let me see let me see
IM
the order, Sani.
Yes, Lord.
Yes, this case has been wrongly listed. This case
IN
has
number
been listed
753 of 2018.
under the heading so and so, full stop. As the appeal is barred by limitation. Full stop.
164 days without delay. I have explained in paragraph
7531 of 2000 under section 5 of the Limitation Act has also been filed. Full stop. Issue notice to the respondent on the limitation matter. Sole respondent. Full stop. Registered covered ordinary process requisites 3 weeks.
Oblaju.
Serial number 33, second appeal 187 of 16. Mr. Akshay Kumar Panto.
Yes, Mr. Mahato. preliminary decree. Yes. Pass over. Yes, Mr. Madhav. Switch on. Switch on. You have muted.
हुजूर
Yes.
इसमें हमारा फाइल मिसिंग हो गया है हुजूर, इसमें हमको रिकंस्ट्रक्ट करना पड़ेगा, इसमें ये 2 हफ्ता का टाइम दिया जाए हुजूर, हम कॉस्ट जो है जमा कर देंगे कोर्ट में, उसको एक कॉपी हमको प्रोवाइड कर दिया जाए।
There is no provision.
सर्टिफाइड कॉपी अप्लाई कर लेंगे हुजूर उसमें, प्लेंट का ये सब का।
Your appeal by the other side was allowed on the ground that the daughters of Nimai Mahato or the heirs of Nimai Mahato, who is also a co-sharer, has not been made a party. So in their absence, the share of the plaintiff cannot be carved out. So what is wrong in this?
हुजूर इसको
The court held that there is unity of title and the jointness of possession also, but no preliminary decree could have been passed in absence of the legal heirs of Nimai Mahato. So
हुजूर फाइल मेरा पास नहीं है, इसलिए हुजूर बोल रहे थे कि टाइम दे दीजिए।
the counsel for the appellant submits that he has lost the case file. First up, he submits that he wants to reconstruct the same. Thus, a prayer has been made to adjourn this case. Prayer allowed to adjourn for what time?
4 weeks कर दीजिए।
4 weeks.
Obliging.
Serial 34, second appeal 191 of 16. Mr. Navneet Sahay, Mr. Manoj Kumar Das, Mr. J. N. Upadhyay for the appellant, Mr. Vikash Kishore Prasad, Mr. Naveen Kumar for the respondent.
Yes, Lord, this case is sole appellant has died, my Lord.
So,
4 week time, my Lord, filed a substitution petition.
why should I grant you time 4 weeks?
Yes, my Lord.
Why should I grant you time 4 weeks? It is the statute which grants you time, and statute prescribe what happens if you don't file. Tell me. The consequence is there in the act itself.
Yes.
When did he die?
Today we receive information, my Lord, that he died, my Lord.
Tell
No
me,
date
give me the date.
Date maybe not right, my Lord. But due to COVID-19, my Lord, he died.
Okay. Prayer has been made to adjourn this case on the ground that appellant number 1 is dead. We'll stop this. The sole appellant is dead. Adjourn.
Obliging.
Serial 35, second appeal 194 of 16. Mr. Neeraj Kishore, Ms. Vandana Kumar Sinha, Ms. Vipul Vidya for the appellant.
Yes. Who is appearing? Pass over.
Serial 36, second appeal 204 of 16, Mr. Prashant Pavlov, Mr. Mantu Kumar Sinha, for the appellant.
May it please your lordship. My lord, this is a title declaration suit. The plaintiff and the defendants happens to be the lineal descendant of a common ancestor Raghunath Rai. My lord, I can clarify this entire thing, the issue of dispute, my lord, by the genealogical table. May I present it, my lord? That will clarify the situation. The issue was like this, my lord, that if the genealogical table is presented, my lord, in one line, because genealogical table is not disputed.
Where is it?
I am presenting it, my lord. I could not send it. I am presenting it on the screen, my lord. So the dispute pertains only to. Yes, my lord will find in this genealogical table, my lord, this is not in dispute. The dispute has arisen from the fact, my lord will find Raghunath Rai. Now I am, my lord, Ganesh Rai. In the third clan, the lowest, the down bottom, my lord, Raghunath Ganesh Rai. I am the
Yes.
plaintiff. But the dispute is between this Ganesh Rai and the Jogi Rai's grandson, that is Bipat Rai, respondent.
Yes.
First, the admitted position is like this, my lord, that Barju Rai and Yashoda Devi were married.
Yes.
Now defendant has set up a case specific
What is
that
your case?
my case is, my lord, that the property which I am trying to
Who was
inherit,
the plaintiff? Who was the plaintiff?
I am the plaintiff, Ganesh Rai.
So what is your case?
My case is, my lord, that Jhagru Rai, my lord will find from Phagu Rai's second son, Jhagru Rai. So he died issueless. That is my case. And therefore, I inherited his property being sole legal heir. My right is being contested by Bipat Rai. And Bipat Rai has set up a case, my lord, saying that my father, this Barju Rai died, and Yashoda Devi got married to Jhagdu Rai. Am I clear, my lord? In Chumona form of marriage. Devi got married to Jhagdu Rai in Chumona form of marriage. And I am the son of the wedlock of Jhagdu Rai and Yashoda Devi. This is a fact he has agitated in his.
Let me
So,
see. Let me see. Let me see the plaint.
yes, my lord. If my lord will trial court judgment, may I please, my lord?
Yes.
My lord. So page 24, my lord, para 3. May I place it, my lord, or my lord will go through it?
Just a minute.
My lord.
Yes, 3.
Para 3, my lord. May I please it, my lord?
Yes.
The plaintiff's case in brief is that Raghunath Rai was the common ancestor of both the parties. The said Raghunath Rai had three sons, Yogi Rai, Bali Rai, and Fagu Rai. Yogi Rai died leaving behind him one son, Barju Rai. Barju Rai died leaving behind him two daughters, Bhado Devi and Bikni Devi, and one son, Bipat Rai, the defendant. Bali Rai died leaving behind him one son, Kishu, who died leaving behind him Vibhishan. Vibhishan also died, leaving behind him Mohanlal. Fagu Rai died, leaving behind him Chetu Rai and Jhagdu Rai. Chetu Rai, who died, leaving behind him Fusan Rai, and Fusan Rai died, leaving behind him Ganesh Rai. The plaintiff. Jhagdu Rai died issueless. It is further case of the plaintiff that defendant Bipat Rai is the son of Barju Rai, who died in the year 1960. Jhagdu Rai was married at Moja uh, Jhala, P.S. Mosi so and a daughter was born out of the wedlock, but she died at the age of 10 years, and accordingly, Jhagdu Rai dies issueless, and thus Ganesh Rai alone remained the surviving heir of the branch of Phagu Rai and inherited the entire property recorded in the name of Chetu Rai and Jhagdu Rai and came in possession thereof. It is further case of the plaintiff that defendant Bipat Rai is illegally claiming himself as son of Jhagdu Rai. It is alleged that Bipat Rai is owner of in possession of property left by Yogi Rai, being the sole surviving male heir, but in order to grab the property of the plaintiff, he is maliciously setting up himself as the son of Jhagdu Rai. The defendant has managed a report to be prepared by Karamchari and Anchal Adhikari containing himself as son of Jhagdu Rai, which is forced and fabricated. He is further trying to get his name entered in the recent survey settlement in respect of the property of Jhagdu Rai, claiming himself to be his son. The act of misdeed of defendant occasioned the filing of the suit. The defendant appeared and contested the suit by filing written statement, praying therein to dismiss the suit on the ground inter alia that the suit is not maintainable, that the suit is bad for the defect of non-joinder of the parties, that the suit is barred by law of limitation. The defendant has admitted the genealogy given by the plaintiff in the plaint, with one difference that Bipat Rai, the son of Jhagdu Rai, who did not die issueless. It is alleged that Barju Rai was married with Yashoda Devi, who gave birth to two daughters, namely Bhado Devi and Bhikni Devi. After the birth of two daughters, Barju Rai died, and his wife Yashoda Devi subsequently solemnized a marriage in Chumona form with Jhagdu Rai, who was the widower of the defendant, with widower and the defendant took birth from the wedlock of Jhagdu Rai and Yashoda Devi in the year 1944. It is pleased it is pleaded that Barju Rai did not die in the year 1960. This defendant has further made out a case that Chetu Rai and Jhadu Rai had separated themselves amicably without any partition by meets and bounds, and defendant is in possession of the property of his father Jhadu Rai, which possessed in his lifetime and paying rent to state. Yashoda Devi, the mother of the defendant, died in the year 1986, and post cremation ceremony was performed by the defendant. The property of Barju Rai is in possession of Bhado Devi and Bhikni Devi. My lord, this may be taken note of the two daughters. The possession, it is said that they are in possession. The property of Barju Rai is in possession of Bhado Devi and Bhikni Devi. Since the defendant is the son of Jhagdu Rai, he has got equal right, title, and interest and share in the suit property, which is being possessed by both the parties in accordance with their rights and convenience. It is alleged that admittedly Yashoda Devi was married with Jhagdu Rai, who died in after 1956, and thus the defendant, being the son of Yashoda Devi, is entitled for one half share in the suit property. It
Why
is
one
further
half share? Why one half share?
that's also we don't know, my lord, because if he is in the clan, then three is one half share uh,
Because it is his case
that he is the absolute legal heir of.
that Chaitu Rai and Jagru Rai were separate.
Yes,
If that be so, it should be the entire property of
entire property of Jhagdu Rai. Then he says
yes.
half share in the suit property.
Go on.
It is further pleaded that plaintiff executed Bhukt Bandha, ignoring the defendant's claim in favor of some muscle which was challenged by the defendant in RM case number so and so before the court of SDM Devgar, in which Karamchari, CI and CO reported that defendant was the son of Jhagdu Rai. And Bhugat Bandha was illegally, and on that basis, Bhugat Bandha was set aside. Thus, the plaintiff has no cause of action for the suit, and the suit is liable to be dismissed by declaring half share of the defendant in the suit property. On the basis of pleading, my lord, the parties' following issues have been settled and recast for the proper adjudication of the suit. 4, 5, 6, 7, my lord, these are the 4 issues. My lord, whether the genealogy given by the plaintiff or that is correct, whether the plaintiff is the only heir of Chetu Rai and Jhagdu Rai, whether the defendant is the son of Barju Rai or Jhagdu Rai, and whether the plaintiff is absolute owner of the suit property, whether then, my lord, whether the plaintiff is entitled to relief as claimed for, to what other relief, because there were 2 suits, my lord, partition suit and this declaration suit, both were amalgamated, so issues have been taken jointly, my lord. The last 2 issues pertains probably to the partition suit. And I presume, my lord, if he has pleaded that they have gone separate, but maybe that for the reason that Fagu Rai's right has been claimed to be half between Chitu Rai and Jaggu Rai. That may be the reason, my lord. My lord, if my lord will come, if my lord will allow me, I have gone through the judgment, my lord. The aspect which was dealt by learned court below.
Now, just answer some questions.
My lord. My lord.
Both the courts have held that Yashoda Devi got married to Jhagru Rai.
My lord.
This is a question of fact.
My lord.
Yes?
Now the perversity lies, my lord. What the court has taken into consideration, that court has said that it is burden lies on me to dispel that contention set out by the defendant, that yes, they were not married. Actually, it is the defendant who has set out a case of Chumana form of marriage. So it was under 101, my lord, under Evidence Act. If my lord will kindly see.
So on what basis the court has held that she was
Yes,
married?
2 aspects has been taken, my lord. If I am just that my oral evidences that I have adduced, the evidences has said that I have not seen this Barju Rai and the 50 years, 60 years before he died. So this 50 years, 60 years, the court has computed in mathematical niceties approximately when it was said. Then he says and comes to a conclusion that his death is of 1944, 43, and the birth of the child, this Bipat Rai, is of 1942. So our case that he died in 1960.
So what is the material which the defendant has brought to show that he is the son of the
that is the CO report, my lord. That that is dealt, my lord. If I am allowed to place, my lord, this my lord will just have a kind look to page. Discussing the issue. Page 29, my lord, internal page 7. If my lord will kindly come to 7 line from the top, my lord. Thus, from the testimony of plaintiff, my lord has got it.
Just a minute.
7, 8 line, my lord. 3, 3, 6, 2, 8 line, my lord. Thus, from the testimony. My lord has got it, my lord.
What is this migration certificate?
He
Exhibit
he has produced one school migration certificate, my lord.
dated.
Yes,
Dated.
yes. Dated, my lord. I'm just. It is dated, my lord. Exhibit A is dated, my lord. I'm just placing. The judgment does not disclose, but it will be after 50 because his birth is 42, my lord. That is being shown. But our contention was, my lord, in reference to Honorable Supreme Court's judgment, that even if a document, that is, my lord, the reported judgment, 2010, yes, 9 SCC 209. My lord, this judgment clearly holds that any document, school record, has to be proved in civil dispute in the same manner as any other document. He has come with a document and it has been taken to be gospel truth. On the face of it, it has been accepted. And it has been said that.
What is this RM case number 189?
Yes. This is, my lord, I had executed, this plaintiff had executed, that is a case set up by the other side, that a Bhukt Bandha mortgage I had executed in favor of some person, and this mortgage was challenged by the petitioner, this defendant, and in that course, my lord, a report was submitted by the Karamchari and Circle Officer saying that this defendant, he happens to be the son of this Jhagadu Rai. So based on that, it has been cancelled. Revenue miscellaneous case. We have said that we have not executed, we are not aware, we have not executed any wakalatnama. Now they have produced one document saying that you had accepted the marriage of Jhagadu Rai with this Barju Rai, is the Yashoda Devi, my lord. So that is RM case. That is one document that has been taken into consideration.
LCR is there? LCR is there?
No, NCR has not been called for, my lord.
What LCR?
So the question of law, my lord, that I had formulated under 101, since defendant had set up a case, so the onus was on the defendant to establish, because admittedly Yashoda Devi was wife of Barju Rai. Now he has set up a case that both are widower. This Jhagadu Rai and Yashoda Devi, they married.
Let us see this document, Exhibit D, another document.
My lord. So LCR is called for, my lord.
Yes.
My lord.
For the lower court records, as it is necessary to see Exhibit D and the document, which according to the court below, courts below, is in favor of the defendants, in favor of the respondent. So tough.
Grateful, my lord. So my lord, we have to deposit cost, or the court, it has to come through.
It will come through the official process.
Grateful, my lord.
Serial 37, second appeal 285 of 16, Mr. J. Upadhyay.
Yes, my lord. These two appellants had been died, my lord.
When did they die?
One death certificate आपको मिलो 29/7/21 मिलो
721. It has been submitted that both the appellants are dead. Full stop. This case is thus adjourned to file necessary petition of the affidavits.
Serial 38, second appeal 288 of 16, Mohammed Imtiaz.
Yes, yes. We're not. There's some problem with you log out and again.
मिला, हुजूर खोज रहे थे मिला नहीं, पुलिस 4 सप्ताह का टाइम दे दिया जाता है। Wanting 4 weeks time to preparing.
Why?
Because copy of memo of appeal is not available. रखा गया मिला नहीं।
The on the ground that memo of appeal documents are not. Full stop. This case is thus adjourned for 3 weeks.
Serial 39, second appeal 291 of 16. Mr. Bhaiya Kumar, Mr. Sachin Mato, Mr. Sahil.
On behalf of the appellant, my lord, one indulgence I require, my lord. Let it be in the next week, my lord. One document I have to see, my lord. Verify Exhibit 3. It is the sale deed. By virtue of that sale deed, my lord, the plaintiff appellant has purchased the property. Now I have to verify whether in the sale deed is there any dimension is mentioned in the sale deed. Then, my lord, I may argue, my lord, that the trial court should have appointed leader commissioner to verify the land.
On the request of Bhaiya Vishwajit, there's this case after 1 week.
Obliged, my lord.
Serial 40, second appeal 219 of 19, Mr. Pratyush Kumar, Mr. Prashant Kumar Srivastava. For the appellant, Mr. Vikesh Kumar, for the respondent.
Lord, Lordship, may I submit one thing in this case, Lordship?
Yes.
We have filed caveat in this case, so our name is coming. Now they have filed a stay petition. That copy has not been served to us, so we could not.
I'm sorry, Lord. I tender my apologies. Unfortunately, Lord, it really missed my mind. I was ready to argue, but.
Where is the question of stay without admitting the second appeal? Yes.
My lord. My lords, this is defendant's second appeal. The suit was decreed. Thereafter, Lord's defendant's preferred appeal. The decree of the trial court has been confirmed, and the decree of the plaintiff has been confirmed, Lords. Lords, the substantial question of law which arise for Lordship's kind consideration would be that, firstly, Lords, that the suit was filed by one Ajay Agarwala. They pleaded in the plaint that it is a property belonging to the firm, but they led evidence that the property is actually in the name of a company. Now, in the individual capacity, he has filed the suit with respect to 2.56 acres of land of plot number 183. Now, the defendant raised a defense saying that I am in 1.65 decimals in plot number 183, plot number 183. But we said that we are in khata number 1. They said that this is in khata number 2. Whatever that may be, the learned trial court gave a finding that since the boundary descriptions are similar, without applying the judicial mind to the fact that plaintiff was claiming about 2.56 acres of land, and the defendant was claiming only with respect to 1.6 decimals of land. On that basis, it says that since the property involved is same, accordingly, I am deciding the further issues. Lords, the third aspect is, the firstly, Lords, is that the suit was by the individual. In the individual capacity, the property was belonging to the company. Secondly, Lords,
How do you say that the suit was filed in the individual capacity?
Lords, just kindly see trial court decree, my lords.
Yes.
And the entire judgment says,
Yes. Tell me how.
yes, Lords, Ajay Agarwala, son of Rajendra Prasad Agarwala, resident of so-and-so, Dhanbad, for and on behalf of Jharia Firebricks and Pottery Works Limited.
So
Now,
the suit is by the Jharia Firebricks Pottery Works Limited.
Lords, the
Represented by
trial. No, Lord,
represented by Agarwala.
no, the plaintiff is not Jharia Firebricks, my lords.
Who is the plaintiff?
Ajay Agarwala, because
No.
the entire suit has been craftily drafted, my lords, in a fashion that Ajay Agarwala gets decree for 2.65 acres of land belonging to the company. And my lords, one more thing.
On behalf of Jharia Firebricks.
Lords, because if your lordship sees, and another aspect to lordships, my first submission is this, that it is on behalf of Ajay Agarwala only. The second,
No. It is on behalf of the Jharia Firebricks.
and Lord, the second aspect is, even if your lordships is of the opinion that prima facie, if your lordships it feels that it is filed by the plaintiff company, then even in that respect, my lords, the private document, which is a board resolution, without formal proof has been admitted into evidence. This is a very trick, a ruse to actually get a decree in the, because the entire judgment, if your lordship sees, entire judgment, the courts have said the plaintiff's company, apostrophe S.
That is the
Apostrophe S, plaintiff's company, not.
You cannot take benefit of that.
No, Lord, another aspect is
the judgment. Yes.
No, Lord, the other aspect is, if your lordship sees the trial court relief portion. If your lordship may kindly, Lord, I'm just showing you lordship what the relief has been claimed.
Read from paragraph 2.
Lords, we kindly just see the relief, my lords, for a moment, in the trial court decree. It is important.
Yes. Yes.
For a decree in favor of the plaintiff and against the defendants declaring the title of the plaintiff of the suit land, for a decree in favor of the plaintiff and against the defendants confirming the possession of the plaintiff over the scheduled land, and alternatively, if found dispossessed, for restoration of possession of the suit land. Now, your lordships, may I come to your lordships trial court judgment. So, and for permanent injunction also, third prayer was of permanent injunction.
Yes.
So the suit was essentially for declaration of right title interest and for confirmation of possession, because they said alternatively for recovery of possession if found dispossessed. Now, what is their case? The suit is not maintainable because, now I'll come to that, Lord, but kindly see para 2 onwards.
Yes.
The plaintiff has claimed above the reliefs on the basis of the grounds raised that the plaintiff is one of the directors of the firm. Kindly see, Lord, they are saying firm, but they are leading evidence that it is a company. Name and style Jharia Firebricks, and the above firm has its office at Dhansar in the factory premises at Dhansar. The plaintiff, being the director or one of the directors of the firm, is competent to file the suit on behalf of the firm. The land of the factory is on various plots and including plot number so-and-so, khata number so-and-so.
Mr. Pratish Kumar, stop here.
Yes,
one of the directors of
yes, the word director.
File the suit on behalf of the firm.
Lords, director cannot file with director and firm. Those are two disjunctive terms, Lords.
See, it is Jharia Pottery Private Limited. It is a company.
It's a company. It's a company.
Merely writing a firm, it will not become a partnership firm. So
yes, certainly, Lords.
Proceed.
Certainly. Now, after payment of the valued consideration amount to the vendor, the execution of the sale deed put the purchase in possession the lands as above, sale deed including the land and schedule of plaint. After coming the possession of the suit land, the plaintiff applied for mutation of the factory. Now, they are claiming on the basis of of the deed of 1955. And thereafter they say, it is clear that plaintiff is rightful owner and suit lands continuous with the help and so-and-so. The plaintiff has already mortgaged the property so-and-so acres, 2.56 acres of plot number so-and-so with banker. The defendant is in the month of January to requested the plaintiff that the defendants wanted to start a tea shop over the land of the plaintiff and assured the plaintiff that defendants shall vacate the land in favor of the plaintiff as and when the plaintiff will desire. Defendants also promised to supply tea in the factory of the premises, and defendants promised to pay rent of the tea shop, so and so. On request of the defendants, the plaintiff allowed the defendants to run a tea shop below and without any rent as per assurance, and to vacate the land in favor of the plaintiff when required for the reason best, so and so. And they on 19/3/2006 in the morning started digging foundations over the suit land and started declaring that they will go on with the construction work. On objection, the plaintiff defendants grew adamant of create troubles, and accordingly certain proceedings under CRPC, and accordingly valuation on things like that thereafter. The relief has been thereafter, Lords. Now, Lords, the thing to be looked into, your Lordships, is that I'm in possession. Lords, one important thing, Lords.
Continue.
Lords, one important point, Lords.
Paragraph 3.
Lords,
let me hear what is your case, Mr. Pratish Kumar.
Yes, Lord. Defendants appeared and filed a WS. They have taken regular defense like suit is not maintainable either in law or on facts. There is no cause of action thereafter res judicata. It is further assertion the plaintiff has no locus standi to file the present suit, and one of the directors of so and so of firm of Jharia, Fire Bricks and Pottery, and no paper has been filed to convince that the said firm has authorized the plaintiff to file the present suit, and this court the suit is liable to be dismissed. The defendant denied the para statement so and so and said to the plaintiff to prove the extent that the alleged firm of Jharia so and so Pottery Works managing director and who has bare entitled to file suit as plaintiff has not been delegated any paper to present suit, and the suit falls for non-inclusion of all documents. The defendants have denied statements made in paragraph 4 to 6 of the plaint, as these matters or documents is not admitted by the defendants. The further stated the suit is bad for the reason the alleged purchase is the name of factory, and therefore the firm as well directors and necessary parties. Defendants deny the plaintiff lawful title, and the defendant stated that the defective non-disclosure. Thereafter, Lords, it is important that the suppression of real facts so that the plaintiff claimed to have purchased the suit plan so and so Dhansar, but failed to disclose the total area of plot and who was the rightful owner of the said plot. As on perusal of the name, the rightful owner is unknown, and no rightful owner derived title is under below. It is also surprising the plaintiff that the plot number has mortgage with bank purposely did not disclose the date and alleged mortgage as the nature of mortgage. The defendant reiterates that the plot number 183 is under khata number 1 and not in khata number 2 as wrongly alleged in the plate. The actual owner, BP Agarwala and Sons, while owner owned and possessed sold 2 khatas of land out of plot number 183 by executing and registering a sale deed dated 30/1/90/90 being deed number 11356, and the land sold containing 2 dwelling house in favor of Prabhavati Devi, wife of Sri Dharmanand Lal, and on consideration money and from the purchaser Prabhavati Devi, she had been delivered possession thereof, and she lived in the house. The defendants have stated that the statement made in para 7 to 9 of the plaint are incorrect, baseless, are categorically denied. The defendants state that the plaintiff never possessed the suit property when purchased by the defendants. Further submitted the defendant that Srimati Prabhavati Devi, while an absolute owner and exclusive possession of purchase, sold the same in favor of Khublal Yadav, that is the defendant number 1, a son of Jadu Yadav, executing, registering sale deed dated 21/3/2002 being deed number so and so, since the date of purchase the defendant were residing in this property being portion so and so, including the defendant soon after purchase applied for so and so mutation, mutating the name of the property covered under the deed dated 21/3/2002, and mutation case was registering mutation case and course of mutation proceeding. Revenue authority held inquiry, found possession of the defendant and satisfied the ownership, pleased to grant mutation, and correction slip thereafter issued, and thereafter the answering defendants further state that the plaintiff has got nothing to do with the suit property in ownership, possession so and so. The defendants have further stated the statement so and so. So, Lords, the defendant one is absolute owner and possession of part of plot number 183, measuring an area of 1 kattha 1.65 decimals. land on a registered instrument coupled with possession, therefore, and the plaintiff or anybody of the firm cannot possess the property in question. The plaintiff has filed the suit in part of plot number 183 of Khata number 2, whereas the answering defendant own and possess Khata number 1 land together with house Khata number 1. And the plaintiff is totally confused by making allegation that this plot relates to Khata number 2, therefore has no concern with the property owned, and thereafter lords it has stated so. So the ये एक टी स्टॉल चला रहे थे उसमें. This is the case, lords. Now, if your lordship sees the relief portion which I have shown to your lordships, the suit, and if lordship may kindly see the issue number 4, next page, my lords, is the suit plaintiff entitled for a decree of right title interest and confirmation of possession of the scheduled land. So essentially, my lords, this was a suit for decree of declaration of right title interest and confirmation of possession. In the plaint, there is a specific averment that I have been already delivered possession, because the alternative prayer was for recovery of possession if found dispossessed. So they are saying that we have handed over possession to you for running a tea stall, and accordingly we are filing a suit for confirmation only. The suit is not maintainable, my lords, ex facie. So, lords, the direction, because if your lordship sees, the direction by the trial court is for to vacate and for recovery of the suit premises. The suit was not maintainable for that. If your lordship sees,
yes,
the direction part of the learned trial court. Apart from the other fact which I'll come to your lordships, kindly see the direction part. Lord, on this score only, this appeal can.
yes.
Yes, lords.
What do you mean to say?
Lord, the suit is for confirmation of possession. I am in possession as per the plaintiff's own pleading. The alternative relief was for recovery of possession if found dispossessed. That is during the pendency of suit. So the relief was only for confirmation of possession. Even if title, for a moment, if I assume for a moment title is declared in their favor, then the suit was not maintainable.
Why?
Because it was for confirmation of possession. I am in possession. The finding is that is why the direction for recovery of possession.
What is the nature of your possession? If there is title, what is the nature of your possession?
No, the question is this: the suit has been.
Possession. I'm asking you. If you say you are in possession, what is the nature of your possession?
Lord, the question is, lords, my nature of possession is by way of rival title, by virtue of a sale deed executed in favor of Prabhavati Devi in 1990, and by BP Agarwala, who is the family member of the same HP Agarwala who sold it to Jharia.
Yes.
So there is a commonality of interest also, because the exhibit 3/1, which is the sale deed executed in favor of Jharia Fire Bricks and Company, that deed is executed by HP Agarwala, BP Agarwala and others.
Yes.
So if the suit exhibit 3/1 was in respect of 2.56 acres, then lords, it cannot be said only on that basis that if BP Agarwala executes a separate independent suit in the year 1990 in respect of 1.65 decimals of land only, and which I am in possession. Now they are creating a case as if that they have without any document given a possession of the company's land to me. By whose authority? How will a company give a land to somebody, lords? I am in possession. They admitted that in plaint. They filed a suit for confirmation of possession only. There cannot be a decree for recovery of possession on the suit which has been filed for, because the frame of the suit Lords, the CPC has to be applied strictly, Lords, as regards the relief portion is concerned.
Yes.
Lords, may kindly appreciate that if the suit was filed, because I am also claiming title, rival title. And they say that I am in possession. And my possession hinges upon
What happened? What happened to title suit number 80 of 2006?
Lords, that is not further stated what happened to that.
You must be knowing.
Lords, I can ask my client because I don't have that specific instruction today.
That was a suit filed to cancel your sale deed.
Not my sale deed. That was a suit filed by Jharia company against the sale deed executed by BP Agarwala in respect of others.
Prabhavati, you purchased from whom?
From BP Agarwala. Milords, may kindly appreciate one thing, Lords, that I have placed the relief portion of the plaint, Lords. The trial court decree also contains that. Lordships will find that I have a sale deed in my favor executed by BP Agarwala, and BP Agarwala holds a title as per Exhibit 3/1 of the plaintiff's own case. No, they should have sought a decree for declaration that the sale deed is illegal. There is no such declaration, Milords. In absence of any declaration that the sale deed dated of 1990 executed in favor of Prabhavati Devi by the Agarwala, the suit is not maintainable on that score also. Because as per their own document, BP Agarwala has title, and their relief in the plaint does not challenge the sale deed. They have not challenged the sale deed. They have not even, the sale deed is of the year 1990, and Milords, they could have challenged that within 3 years. Now, even if they want to get a declaration that the sale deed is not binding upon the plaintiff company, then there ought to have been at least a declaration to that effect, Milords. There is no relief claimed with regard to my sale deed, neither of 1999 nor of 2002, which was executed by Prabhavati Devi. So as per their own document, if your Lordship sees, it says Exhibit 3/1. Milords, I have a certified copy of the documents with me. If your Lordships can post it on a physical day, I can show it to your Lordships. And one more thing, Milords, the plaintiff says that this is a suit filed by the company. For a moment, now they produce a document for the company beyond pleading. But anyway, now, Milords, the board resolution, which is a private document, Milords, as per Section 74, read with Section 75 of the Evidence Act, that has to be formally proved. Milords, without formal proof, that's a statutory requirement of law. A board resolution has been admitted into evidence. And the court-wide order dated, Milords, the wide order dated 1/2/2010 has said that it is a public document, as such I'm admitting it into the evidence. Milords, in my respectful submission, a board resolution of a company, by any stretch of imagination, it cannot be a public document. And such formal proof is the statutory requirement. So on this score also, if the plaintiff comes forward, files a suit, even on behalf of the company, then without board resolution, it is not maintainable, Milords. The suit is not maintainable on various counts. Milords, firstly, the relief has not been claimed properly, Milords. There is no declaration against the sale deed. Both the sale deeds in favor of Prabhavati Devi and in favor of BP Agarwala, in favor of the Khublal Yadav defendant of 2002. These two. Lords, I purchased it from Prabhavati. Prabhavati purchased it from BP Agarwala.
So that is why I'm asking you, what is the status of that suit wherein the sale deed executed by Prabhavati Devi has been challenged?
No, Milords. The sale deed of Prabhavati has the sale deed of Prabhavati, Milords, if had been challenged in that suit, then I can verify it. But Milords, that is not before this trial court, Milords. That was not part of the record. If your
Just
lordships want,
see, in the judgment, it has come the title suit number 80 of
yes, sir.
2005 for cancellation of sale deed through which Prabhavati Devi sold land to Harelal Jadhav. Who is Harelal
Lord,
Jadhav?
Lord, that is a assertion, Lords.
Who,
That is an assumption.
who is Harelal Jadhav?
Harelal Yadav.
Harelal Jadhav?
Harelal Yadav is not party here. He must have purchased it from Prabhavati Devi, if at all.
He's another purchaser.
He is another purchaser with which we are not concerned. Because I am being sought to be dispossessed in respect of 1.65 decimals of plot number 183. It's a small piece of land. I am a small person. And Lord, the suit is not maintainable under any score. Because there is no declaration with regard to, because in that suit that there might be a challenge. Maybe. But in my suit, there is no declaration. There is a 2000, because if there is a sale deed, below, then in view of section 114 of the Evidence Act, clause illustration G, there is a presumption of correctness of all judicial and official acts. So a person cannot file a suit and merely wish away a title without even challenging the same. And below, the suit has been filed for confirmation of possession, and the decree has been granted beyond the relief claims for recovery of possession. And I'm residing there with my family members. I'm running a tea stall. I'm a small person, and I have an independent title. Lord, this appeal needs to be heard, Lords, in my respectful submission. And there is a board resolution, Lords, that has not been exhibited because without formal proof, that's a statutory requirement. A formal proof of a document cannot be relaxed. Of a private document, it has to be formally proved. A board resolution, they file it.
The board resolution was for what purpose?
For showing that Ajay Agarwala is duly authorized to present the plaint. Without board resolution, he cannot file the plaint. He cannot institute the suit. Board resolution is a must, Lords. A company may be a juristic entity, but it has to be represented through the director, the principal officer. Order 29 very clearly says of the CPC who can present a suit.
Yes, read that.
Order 29. In suit by or against a corporation, a pleading may be signed and verified on behalf of the corporation by the secretary or director and other principal corporation who is able to depose on the facts of the case.
Yes.
Now the word is, Lords,
Yes.
in the suit by or against corporation, the pleading may be signed and verified on behalf, the word is on behalf of the corporation by
Yes.
the secretary or by the director or
Yes.
other principal officer of the corporation who is able to depose to the facts of the case. Now, my lords, the board resolution says that he is the director. The plaint does not say that, the cause title does not say that he is the director. The pleading says,
So
but the board, but
it is enough.
no,
The
but
pleading-
without a board resolution, the suit is not maintainable, Lords, in my respectful submission. Civil suit is not maintainable without a board resolution.
Show me how are you saying this?
Lords, I have to show the authority, Lords. Today I have not brought it. Lords, I can show it to authority.
Then you have come with this your main argument and you are without authority.
Lords, my other arguments, if Lordships will kindly see, the other arguments are...
You answer this. Are you sticking to this argument? If you are sticking to this argument, show me authority. That if a suit is filed and director says, yes, I am a director, I am filing this, then
Lords, his oral statement will not be suffice, Lords.
show me that. And
Lords, he has to
is it a case you have disputed in your written statement that he is not a director and he is not entitled to file the suit? Is it your
Lords, we have stated
in written statement you have taken this ground?
that
Read your written statement, whether you
yes.
have taken this ground or not. In which paragraph?
Para 6, Lord, the plaintiff has no locus standi to file the present suit as plaintiff claimed to be one of the director of the firm Jharia Fire Bricks and no paper has been filed before the court to convince that the said firm authorized the plaintiff to file the present suit, and on those score alone it is liable to be dismissed.
Is it your case that he is not the director?
Because it is for the plaintiff to prove all these facts. It is the initial burden of the plaintiff to prove he is the director. Lords, I am not supposed to prove he is the director. Lords, he has failed to prove that he is the director.
You haven't disputed.
Lords, it's not required to be disputed. If a plaint is presented by the plaintiff saying that I am so and so, I have the title so and so, I am the director so and so of the company, then Lords.
So Mr. Counsel, what needs to be proved?
Lord, the initial burden of the plaintiff to discharge certain facts. Plaintiff will prove, Lords, that he is the director. Lords, in respectful submission.
Suppose if you don't deny the fact that he's not the director.
So the initial burden does not shift.
If you admit that he's a director, is it necessary to prove that?
I have not admitted. I have not admitted. If Lordship sees,
that's why I'm saying that show me your denial. Your denial has to be specific. Then the question of your proof of the plaintiff.
Lord's admission, there is no specific admission. Lordship will kindly see that the plaintiff has no locus standi to.
दीजिए तो CPC दीजिए.
Lords, para 8 may be permitted to read, Lords, in regard to that.
Read that.
That the statements made in para 4 to 6 of the plaint are matters of documents does not admit this has a correct interpretation made at the time of hearing. That the suit is bad for the reason that the alleged purchase in the name of factory, therefore the firm as well as all the directors are necessary and proper parties. In their absence, the suit cannot proceed. So we are all saying that there has to be a director. Otherwise, Ajay Agarwal, he may not be the director.
Have you stated that Ajay Agarwal is not a director?
Lord, the question is this: the initial burden of the plaintiff has to be discharged, Lord. My respect.
First say it's not the initial burden. He has made a statement that yes, I am a director. Then you have to counter saying that yes, he is not the director.
If I don't admit that he is the director, then he has to show that he is the director, Lord. This is what my submission is.
I'm asking you what is the denial in your written statement?
Lord, my statement in the written statement is I'm not admitting him to be the director. I'm not saying that he is the director. Then, Lord, in my respectful submission, it was for him to prove that he is the director.
You stated that he is not the director also.
Lord, it is not required that I should say specifically that he is not the director. But what is required is that I am not required. I have not admitted him to the director. I don't know him.
Have you stated that I don't know him?
Lord, this is what I'm saying. This is what I'm saying. Para 6 and 8.
Denial has to be specific?
No, the denial has to be specific with regard to a fact which he's saying that encroaches upon my right. He is coming forward and instituting a suit, claiming to be a person who can be a sham. Lordship, you kindly see the draft of the plaint, Lord. They're claiming title over 2.65 of the land of the company. A board resolution filed by executed by someone, marked as an exhibit. Nobody comes to prove that document. That is taken on record.
What is that exhibit? What is that exhibit?
Lord, the exhibit is
Exhibit 2, Lordship.
Exhibit 2.
and it has been dealt with by the learned trial court, my lord, while deciding issue number 3. Lordship may kindly see, my lord, page 70. It has been dealt.
Lord, I have stated specifically the formal proof has not been done of that document.
Paragraph 10, Lordship may kindly see, of the trial court judgment. I am just assisting the honorable court, my lord.
Yes, yes, yes.
The learned counsel for the defense has raised an objection with regard to non-gender parties on two counts. First, all the directors have not been made parties. In this aspect, the plaintiff submitted the document issued by the board of directors authorizing the plaintiff to conduct the suit in this behalf. The document has been marked as exhibit. The objection of the learned counsel of the document is not specifically related to the disputed property. A perusal of the document reveals that even the document does not specifically relate to authorization, but it contains authorization for company's property and disputed plot being the plot of company. This authorization is sufficient in itself. Some lords, this document was marked with objection, and the formal proof is a statutory requirement. Lord, this is my substantial question of law to be asked before your lordships. I've raised a substantial question of law, lords. Whether the instant suit for bad for non-joinder of so and so plaintiff was the owner, and as such the plaintiff Ajay Agarwala was not authorized in Exhibit 2 abstract of the board of directors dated 10/12/2004, 10/12/2004 was not a public document and was not duly proved, and thus was.
Mr. Sinha, what do you have to say that he says that this board resolution was not proved?
I have the certified copy of the entire audit sheet plots. I can mail it or
unmute yourself.
Improved, and my lord, this document has been marked as an exhibit, exhibit 2, lordship. It has already been proved.
He says that it was not proved.
No, lordship, it was proved in accordance
with
law.
No, I have a certified copy. How you say
it was proved.
Yes.
Let it come in the next week. I'll produce the document, my lord, and the order sheet.
How was it proved?
It has duly been proved, my lord, by examining witness.
I can read it, lord. I have the order sheet.
हम हुजूर को दिखा देंगे इसको।
मेरे पास है सर्टिफाइड कॉपी हुजूर मेरे पास, हम यही पढ़ रहे हैं।
ऐसे बिना ये के डॉक्यूमेंट प्रूफ कैसे हो जाएगा हुजूर? एग्जिबिट कैसे?
हम पढ़ रहे हैं ना, हम पढ़ रहे हैं हुजूर, पढ़ रहे हैं। एक बार मौका दिया जाए। Both parties filed hazari through law. This is order dated 1/2/2010. Both parties filed hazari through lawyer. Learned counsel for defendant is present and submits that the petition filed by the plaintiff dated 8/12/2009 may be allowed, by the documents should be marked exhibits with objection. Heard and perused the record. On 8/12/2009, plaintiff filed a petition to mark the public documents exhibits on which learned counsel for defendant orally submits that with objection the document may be marked as exhibit. Hence the document may be filed by plaintiff. Abstract board of directors dated 10/12/2012 is marked as exhibit 2 with objection upon for plaintiff's evidence. So there is no formal proof.
Just a minute. What do you mean by objection? Why did you accept them to mark them as exhibit?
Not this is the case.
What do you mean by objection thereafter?
This is the case.
What do you mean by objection thereafter?
This is the
formal proof.
With what objection? Tell me. With what objection, Mr. Pratish Kumar? A document. You say that this document be marked as exhibit, but with objection. What objection?
Lords, my respectful submission of formal proof is a statutory requirement, Lord.
Accept, no? See, if both the parties agree to mark a document as exhibit, you say yes, it should be marked. Then what happens? That means you admit that document.
Yes.
You admit execution of the document.
Lordship.
Lords, there are two things, Lords. There are two things.
Just tell me one thing. You said that this document be marked as exhibit, but with objection. Objections means what? With what objection?
Lords, there are two things, Lords. First is the mode and manner of proof. The other is the veracity of the contents of the document.
it may be objection with regard to the content of the document.
Yes,
Content.
yes.
That means you admit that the document is there, but the content I will be disputing.
Lordship. This is the
The
case.
objection means only this.
Lordship.
When you say let the document be marked as an exhibit, but with objection means you object the contents of the document. You don't admit the content of the document.
Lordship.
Now, Lord, the other points, Lord, we kindly appreciate, Lord, as regards the decree, without declaration of my title, Lord, kindly see, there is a sale deed of 1990.
In the suit filed by
Yes.
them. The
No,
suit has
no.
been filed by them. How can your title be declared?
No, without declaration, my sale deed is illegal. There is a sale deed of 1990 executed by BP Agarwala, their family member. They were the joint family.
Now tell me one thing.
My Lord.
There was a sale deed of 1950s.
55.
55 Lordship.
And there is a sale deed of 1990. 2000. 2000.
Then 1990 in favor of my vendor, and in 2002 by that vendor to me.
Yes, 1990. I am taking it 1990. Now it is in respect of a particular plot of land. The difference is khata. Plot number is same. It has come in evidence that there cannot be a same plot number in respect of two khatas of a mauja. Both
Yes.
the courts have come to a conclusion that the property is same. Now, if the property is same, which sale deed will prevail?
Now, Lord, my respectful submission.
Earlier
Yes.
said Lordship.
Lord, my respectful submission is that if a suit is instituted, the relief is claimed, that declaration of right title interest.
Can't the release be molded?
Lord, the relief to that extent, relief of declaration of my sale deed to be illegal without any declaration to that effect. Because in the plaint, they have not whispered about my sale deed. I have brought that, Lord, I have brought it by way of written statement.
Listen to me. They have prayed for their right title and interest.
Yes.
Once, in respect of the same land, the court declares their title and upholds their sale deed. What is the consequence?
Lord, my respectful submission is that court was not entitled to issue a declaration of right title interest without dislodging my title with regard to my sale deed. This is my respectful submission. There is an official and judicial act. There are presumption of correctness that has to be challenged specifically, Lords, by the plaintiff. Without that, the suit is not maintainable. And the suit was filed for confirmation of possession, Lord. They have a decree for recovery of possession that is beyond the relief claimed.
Confirmation of possession in the alternative for recovery of possession.
Recovery of possession.
And there is a specific pleading. Lordship may kindly see.
That I am in possession. If found dispossessed, then have to be read along with recovery of possession if found dispossessed.
And Lordship, issue number 4, Lordship may
Once you are
kindly see.
admitting, once my learned friend is saying that once he is coming forward with a case that you have handed over possession to me, this is what the specific case of the plaintiff is. हम चाय चलाओ, वहां पे रहो. हम बोल रहे हैं कि हम sale deed purchase किया है, purchase a sale deed without challenging my title. They are asking for a declaration of right title interest and confirmation of possession, not asking for a decree of recovery of possession. And without challenging my sale deed, my decree, my possession will be dislodged. Lords. They have not challenged my sale deed. They have asking for.
Therefore, both the parties are claiming that the property has been purchased through registered sale deed from the previous owners. And my lord, for this purpose, separate issue has been framed. Lordship may kindly see issue number 4, which has been dealt with by the learned trial court at page 9. Everything will become clear. Issue number 4, Lordship, internal page 9. 6th line from the bottom, Lordship. Lordship may kindly see now coming to the claim of ownership of property.
Yes.
Lordship. everything will become clear.
Lords, that even if Lords, my respectful submission is the suit, the frame of suit, the relief claimed has to be specific. Without declaration of my sale deed, my title is sought to be challenged. And Lords, because if the suit has been filed for declaration of right title interest and for confirmation of possession, then for recovery of possession, how can I, Lords, in my respectful submission, I'm putting a question to myself, there cannot be a relief for recovery of possession, Lords.
What was the relief prayer?
Relief
What
trade
is
was
my kindly see, my lord? Paragraph 18 of the plaint, paragraph 18.
Read the
That the plaintiff prays for the following reliefs: for a decree in favor of the plaintiff and against the defendants, declaring the title of the plaintiff over the scheduled land; for a decree in favor of the plaintiff and against the defendants, confirming the possession of the plaintiff over the scheduled land, and alternatively, if he found dispossessed, for restoration of plaintiff's possession over the scheduled land. And for a
What is wrong in it?
Lords, if found dispossessed,
What
it
is
is
wrong?
not that they are dispossessed. They have not come forward with that case, Lord. They
Yes,
say
please.
that we have, without any document, given you possession.
There is a specific pleading, Lord.
They have not. Lord, there is no declaration of my sale deed to be illegal. Lordship was saying that if
Just a minute. Just a minute.
Lord,
Just a minute. Whose sale deed was prior in time?
Lord, their sale deed is of 55. My sale deed is of 1990. Their sale deed was executed by 3%. 3%.
The court has held that your sale deed has not conferred any title to you because your vendor did not get any title. Your vendor did not have any title to transfer any, did not have any valid title which could be transferred.
But Lord, without a declaration.
Just a minute. Tomorrow, if Y execute a sale deed in respect of the same property, Z executes a sale deed in respect of the same property. You mean to say that this plaintiff, who is having his title, he will file 11 suits?
No, Lords, no. Lord,
You are praying that you have a valid title. It was you to file a suit.
Lord, my respectful submission to that query of your Lordships is, I go down before Lordships for putting that query. Lords, this is a sale deed executed by BP Agarwala. The BP Agarwala, along with others, also executed.
No, BP Agarwala has not executed sale deed to you in your favor.
In favor of Prabhavati Devi, and Prabhavati derived title. And
so Prabhavati, the court holds that the BP Agarwala has sold this particular plot of land in 1953 to this plaintiff company.
Yes.
He has got nothing to sell. He didn't even have the title to sell to Prabhavati Devi in respect of this land.
My submission for your Lordship's kind consideration would be that if a person who has a title sells a property, then Lords, from the same branch of family, then there ought to have been declaration of my sale deed to be illegal. Without declaration, the plaint is not maintainable. The frame of plaint is illegal. It is contrary to the CPC, Order 6. Because the
Nothing is there. Dismissed.
My appearance, Lordship, my kindly.
Give your step.
Lordship. Oblige.
Yes.
Serial number 41, second appeal 130, 5020, Mr. Rahul Kumar Gupta, Mr. Pushal Kumar. For the
I am a tenant in a rent control matter, Your Lordship. concurrent finding against me on two accounts. First is personal necessity, and the second is default in payment of rent.
Both are
So-
question of fact.
Yes, that is there. Only one thing. I do not want to, Your Lordship, if I was that saint, I should not have accepted this brief. I must admit. So I must not.
What have you said? If you are?
I mean to say that I must justify whatever is there in the appeal.
Yes.
I should not have accepted it if I was not convinced with the brief. This
Yes.
is what I want. Your Lordship, only one thing. As
Yes.
regards personal necessity, the property is of, it is famously known as Bihar Club, Chota Nagpur Bihar Club. Now all the shop rooms are there. The plaintiff, he instituted several suits all against the tenants on the front side of the shop rooms. One of the tenant is the present one, which appeal arises out of. Now, there are, I'll be able to show or lead evidence to show that after he gets possession, Bihar Club, he lets out to another tenant. So as regards personal necessity, at least I'll be able to show that they do not have personal necessity because after getting the possession, they have re-let it out to someone else. But
They say they claim personal necessity.
Yes.
Eviction of the
that has not come.
What is the nature of personal necessity?
Pardon?
What is the nature of personal necessity? They have pleaded and proved.
They need it for the purpose of the club. That is what they have said. That is one. But Your Lordship, default also is there. Concurrent finding that the plaintiff had claimed that since 2006 March, I was not paying rent. Both the courts have concurrently held that from March to 2008 February, I have not been able to produce any rent receipt or any document to show that I had been paying.
Then, under the Act, under the Rent Control Act, any one of the ground is sufficient to evict you.
That is there.
Then,
If that is there,
even if I hold that the ground of personal necessity, which has been set forth by the plaintiff landlord, fails, that every time they get any person evicted, they further put on rent the same premise.
I must also confess, Your Lordship, one thing, that reletting has not come in evidence.
Even if I say that it was reletted, even if I say that the reletting was there, then what about the default?
Default, I have said, in my oral evidence, I have said that I paid.
What is the document to show that you have paid?
No. All the documents which have been produced are strangely prior to the alleged default which has been claimed in the claim. From 80s to 2006, all the rent receipts have been produced.
Dismissed.
May I mention, Lordship, serial number, Lordship, 8.
Serial number 8, you just find out what order has been passed. Some order has been passed, definitely.
Your Lordship, may I mention?
It's serial number 8. How many cases passed over?
Your Lordship, serial number 3 में if nobody appeals, Your Lordship, sir, बस हटा देते थे.
Nobody appeals. Okay, the order has been passed and it has been typed. How can I say that so and so appears? How can I say? Tell me now.
Lordship,
Just a minute. Tomorrow you will download from the YouTube and say that no one appears, and the court is writing that someone has appeared. Everything is now in black and white. It's stored, recorded. I can't do that. Don't make me statement and make this prayer. Yes, 2:15. Yes.
No, Your Lordship.